I'm your host, Casey Smith. Guiding you to financial freedom is my co-host, Brad Lyons. Hello, Brad.
Hi, Casey.
Today we have a special guest, Megan Flores. Hello, Megan.
Hello. Good morning.
Happy to have you with us. Megan is with GDCR Attorneys at Law. Specifically, Megan is, again, one of our guests here that are what we call, our wiser endorsed partners. Megan and her partner, Anne, have done a great job working with clients in estate planning. And so we thought we'd do a session today on wills and power of attorneys and trust, all the things that, I kind of look at it this way. When it comes to financial planning, sometimes it's hard to get people like super motivated to talk about retirement or, the planning for retirement, right? Or insurance in case something were to happen to you. But I think it's only second to like death, right? Getting people fired up to go and sign that will.
Oh, yeah. Yeah, they are not. Some are excited because then they can set it aside and not think about it again. But others, it can be a very uncomfortable meeting. I fully acknowledge that.
Especially, I would think with family issues that come up, and especially maybe blended families, and you have to pick one or the other, or try to pick in both. I just think
contemplating your own mortality is an uncomfortable thing for people, and the hardest part is completing the healthcare directive and deciding what kind of end-of-life care you might like.
Right.
Ever faced with that situation, and it's not an easy thing to think about or discuss with your family members, whoever, you choose to do it. But yes, there are times when people have challenges deciding, who they want involved as well.
So it's probably even harder, obviously, when you have children. Who's in control of the children? Who's in control of the money? If you have a small family, you run out of people pretty quickly.
Yes. I meet a lot of couples that have young children, and they definitely have. It's hard for them to decide who's the right person to take care of their kids should something happen to them. I think, too, that with people, and I'm in this group, having children later, where before their parents or in other, when people marry younger and have kids younger, maybe their parents are in their 50s when they're thinking about, this issue. But as people have kids in their 40s, then their parents are in their 70s and, they may have some health issues or other, challenges that it makes it hard for the children to get comfortable with the idea of naming them, at least for the long term. And as you said, if they have a small family or there are other, complicated family dynamics, it can be hard for them to come up with another, family member that they want to be responsible for their children on a day-to-day basis.
Right. I can see that. Let's back up a little bit to a higher level. What is the purpose of having a will?
The primary purpose of having, not primary, but there are a couple of purposes for having a will. One is, if you pass away without a will, the law in Georgia supplies a will for you. And a lot of people are surprised to find out that if you're married and you have children, it doesn't matter what age your children are, even if they're adults, your spouse shares your estate with your children, unless your children say, I don't want it. But the law is that up to 2/3 of the estate will go to the kids and only 1/3 would go to the spouse. And, most people are like, really? It doesn't all go to my husband or wife? And the answer is no, it does not. And so most people, especially once their kids are adults, want their spouse to benefit from 100% of their estate. And in order to accomplish that, you need a will. So that's one thing. Another issue is if you have minor children and, both parents have passed away, minors they don't have legal capacity to manage money on their own. They need someone who's over the age of 18 to do it for them. And if you die without a will and your child stands to inherit more than $15,000 from you, so a very low bar, you have to go to the courts to have a conservator appointed for them to manage their inheritance. And the conservatorship process is not something that most families want to be involved with. It's ongoing until the child reaches the age of 18. The conservator has to report to the court annually, at least, about what they're using the money for, all the receipts and disbursements. You have to put together a detailed accounting that has to be submitted to the court for review. And in addition to that, the conservators are very limited in the types of investments that they can make on the child's behalf. They can't invest in stocks, essentially. They can invest in treasury bills and money markets, maybe some bonds. I'm not even certain about that. But they can't have a diversified portfolio like, you put your clients into. And so you want a will to avoid the conservatorship and all the complications of being involved with the court. And your will would provide for the creation of a testamentary trust for your child, and name a trustee, a trusted, individual, sometimes corporation, depending on the family situation and the size of the estate. That's usually a consideration there, to invest the money for them and manage it and decide, what to spend it on. That's another big issue for family to consider in terms of why you might want a will, because those are two big things. There are certainly others that we can talk about further if you'd like.
Yeah, so that covers, to me, that's pretty obvious as a person with a family that I definitely want to have a will. I wouldn't want it to kind of leave the chance with the courts, especially. But there's also some other documents that you prepare at the same time. Your power of attorney and your healthcare directive. People get these mixed up all the time. They think it's for when you're gone.
Right.
When really it's not.
Right.
It's for when you're alive. Right? So why do we need a power of attorney?
So I use the term estate planning. I'm talking about not just for when you've passed away, when you're gone, but also planning for your incapacity. And there are actually two documents that are critical in that. One is a financial power of attorney. And so you use that to name someone to manage your finances for you if you can't manage them for yourself for some reason. So maybe you have dementia, or there's some other reason why you can't handle your finances. And
you're in a car accident.
Some families, you're in a car accident, or some people, when they get older and it's not as easy for them to get around, they will turn over the financial management to someone just out of convenience. And that can be done with the financial power of attorney as well. And the other document is called an advance directive for healthcare in Georgia. Some people know the term living will, and that serves the same purpose in Georgia. So with an advance directive for healthcare, you can name both an agent, someone that you trust to make healthcare decisions for you if you can't make or communicate them for yourself, and also to provide, as I was talking about, these kind of end-of-life care where your preferences would be if you're faced with either a terminal condition, or if you're in a state of permanent unconsciousness, which is like a permanent coma where you're not expected ever to wake up. And, I've seen situations where it would have been really great had, my client sign those documents, because if you don't have them in place and something like that happens to you, you end up back with the courts again. Seeking to have a conservator appointed for you for the financial piece of it, or a guardian appointed for you for medical decisions. And I had a client who was only 50 years old. It turned out she had an undiagnosed heart condition, and she had a major stroke. And so she was unable to communicate for some period of time. And even once she could communicate again, she did not have her mental faculties to where she could manage her money for herself anymore, or make decisions about her finances. And we had to go to court and have both a guardian and a conservator appointed for her. And she's going to have that for the rest of her life, that situation. And, she has a long life expectancy. She was only 50 when it happened. Once she, had some treatment, she was expected to live a long life. But with these cognitive deficits, that she wasn't ever going to be able to make those decisions from a legal standpoint for herself anymore. And so she could have avoided that if she'd put in place a medical directive and a financial power of attorney.
There are services that are available online that will do these for people. I've heard that that's not the best way to go about the process. Do you have an opinion on that?
I do. I think that particularly if you want to implement a trust for some reason, maybe because you have young children or in mixed families, blended families where, the spouse is maybe on a second or subsequent marriage and they have children from previous marriages and they want to use a trust to provide for their spouse for the rest of their lifetime, but then have anything that's left get passed on to their children. A trust is the only way to ensure that that happens from a legal standpoint. When people go in and start modifying these, if you use the online service, you're getting just a cookie cutter document. You may be able to punch in they might ask questions that are geared towards getting you to the cookie cutter document that is maybe more right for your particular family situation. But it's up to you then, to read through it and decide whether the legalese actually fits your, what you want. And if you go in there and you tinker with that, it can have unintended results.
And I think that's probably an important point for somebody who's trying to go down that path. They have not seen all the different circumstances that can occur because they simply don't know. Whereas utilizing counsel, who has lots of practice doing this sort of thing, has seen many circumstances and knows of settled law that may not come up in a cookie cutter document. They could actually put themselves in a situation where they have directed the assets, directed their estate towards unintended consequences, as you mentioned, and it really isn't what they wanted at all.
Right. Or, frankly, as much as people hate lawyers and legalese, we're trained to write things in a way that is meant to avoid ambiguities. And so what can end up happening when people tinker with the boilerplate is, they're not trained the same way. They put it in their own language, which for the family coming behind them, while it was very clear to them what they were trying to say, might not be clear to other people. And what ends up happening in those situations is, again, you end up with the courts. You have to go to court and ask the executor that they've named or the trustee that they've named may have to go to court and ask the court to tell them, what does this say? And so that's a lot of expense and complication that can be avoided or should be able to be avoided if you use a lawyer to translate your wishes into legal language that's intended to avoid ambiguities or avoid any kind of uncertainty about what it is that you wanted.
You mentioned trust earlier. Let's talk about the difference between a trust and a will.
Sure. A will, if in a very general kind of big picture sense, it disposes of your property at your death, and can also, if you have young children, it also is used to name guardians, the people who are going to take care of your kids day to day, and also can be used to name conservators if for some reason they inherit something that was intended to go into trust, but for some reason it didn't end up working out that way. And the courts have to be involved in naming a guardian for minor children. But it's a more streamlined process if you've done it in your will. But anyhow, you also name an executor who's is the person that, you've decided that you want to trust to manage your assets. And, their job is to figure out what assets you have, what your debts are, pay your debts, file your final tax return, do a lot of just very administrative tasks. And the job is intended to be fairly short term, maybe, 2 years at the most, depending on whether there are a lot of creditor claims that need to be sorted out. But once that kind of period of time is up, your will is going to say what then happens with your property. And you can either leave it outright to your beneficiaries, the people that, you want to receive the property, in which case that's kind of the end of your will. Everything's done at that point. And those beneficiaries, if they receive the property, as I say, outright, that means that they have complete control over the asset. It's theirs. They can do whatever they want with it. They can spend as much of it as they want. They can give it away to whoever they want to when they pass away or while they're alive. If they are vulnerable to being to financial predators is kind of the way we refer to it, maybe because they have dementia or Alzheimer's or some kind of condition that caused them to not be in full, possession of their mental faculties. There's nothing to protect them from, one of these financial predators coming and, perhaps manipulating them into giving the money to them or leaving it to them when they pass away instead of maybe leaving it to their children or, somebody that might make more sense from a family standpoint. So what you can do in your will is you can provide, this is contained in the language of your will, you can provide for the creation of a trust, which is a relationship where you name a trustee who is then in charge of managing the money on the terms that you set out in this testamentary trust for the benefit of some, your beneficiaries, the people that you want to receive the benefit. There's not much other, a word of the assets you've accumulated during your lifetime. And it's what we refer to as a fiduciary relationship. The trustee can be sued for mismanaging the money or for not distributing the funds to the beneficiaries in the way that it's provided for in the document. And so they have obligations to the beneficiaries to engage in prudent money management and make distributions the way that you intend for them to make it, you being the person whose will we're talking about. Trusts are used in lots of other ways in estate planning for more complicated reasons.
We think about special needs trusts. So if a child with special needs, it allows the assets to be held out, aside from their personal assets, so they still qualify for benefits.
Exactly, like
from the government or wherever.
SSI and Medicaid.
Correct.
So
you're talking about trust inside the will, but the will still goes through probate. Right. There's also revocable living trust, right? That we skip probate altogether.
Right. Revocable living trusts. Some people have heard the term, just living trust or revocable trust. And that is a trust that can serve as what we call a will substitute. It contains all the language that your will might have in it about where the assets go when you pass away and after all the administration is done by your executor. But a revocable trust can, as you said, help avoid probate. If you retitle assets in the name of the trust while you're alive and have capacity, you can avoid a probate. Frankly, Georgia is a state where probate is not super burdensome to go through the court system. There are other states, like we have clients who are residents of Georgia, but may own property, a house in Florida, a beach house in Florida, or a mountain house in Tennessee, and avoiding probate and a probate in the state where the real estate is located is something that you want to have happen. Particularly Florida is a state where their probate is the courts supervise it closely. It takes time and it's expensive. The courts, the way I understand it, and I'm no expert about exactly how they calculate their fees, but my understanding is that it is essentially a percentage of the assets that pass through probate. So revocable trusts can be really, if we have clients that have out-of-state property, we're going to recommend that they have a revocable trust. And at the very least, they put that out-of-state property in the revocable trust to avoid probate in that other state. But revocable trust can serve other purposes for planning. It can help if you become incapacitated with transitioning management of your assets that may be more seamless than if you were to use just a power of attorney to do it.
Is that because the bank account would be titled in the trust?
That's exactly
right. And then you've already named a successor trustee or a co-trustee, possibly?
That's exactly right. That's exactly how it works.
Does that mean that they could sign for the checks as well if it's in the revocable trust?
Yes, right.
If the grantor, the person who puts the funds into the trust, can no longer serve? That's
exactly right.
And what does it take for that to happen? Does it take a doctor's note, or does it take a...
you can approach it that way, but in our experience, doctors, it can be hard to get the doctor's note.
Yeah. I've heard this.
There may be situations where it's not quite so clear cut that the person's lost capacity and the doctor's not prepared to give that opinion yet. So the way we usually approach it is we have a committee of trusted family that participates in the process. We may require that the doctor agree with the family, but we don't have to do that. It can just be family that decides maybe by majority vote that you've reached the point that you don't have the ability to make sound financial decisions anymore and trigger this successor trustee coming in to take over the financial management from you through the trust.
So in the trust standpoint, the successor trustee is actually a little more powerful than a power of attorney.
It is. First of all, the power of attorney does require a doctor's note. So you can avoid that with the trust. We also have encountered a number of situations, quite a few actually, where big banks they are reluctant to accept powers of attorney. They are risk-averse institutions, and it's hard for them to know whether a power of attorney has been revoked.
That's one of the things that I had seen where they want to see a continued power of attorney being, re-upped every 3 months.
Right. Yeah, if there's any age on the document, I would say if it's 3 to 5 years old, there's a fair chance you might get some pushback, or your agent, the person you've designated, might get some pushback when they try and take that power of attorney to a bank and use it. And there is not the same resistance when you have gone, jumped through the hoops of creating this trust and naming a successor trustee to act. And you have to retitle the assets. So they know that this relationship is still in place that way.
I think some people get confused too on the retitle of assets. And a lot of attorneys will create trusts. They're not cheap. They're not super expensive, but they're not cheap. They'll create the trust and then say, here's your documents. But then the house was never transferred in the trust. The bank account was never transferred in the trust. The brokerage account was never transferred in the trust. And so it's important that our listeners understand that it's important if you do a revocable living trust or a living trust, that those assets get retitled. But to be clear, you kind of picture umbrellas. So a trust would cover your home, your checking and savings, your cash, even really your material possessions, all kind of get lumped into that trust. But your IRAs, your Roth IRAs, your 401k, those have nothing to do with the will, have nothing to do with the trust. It all passes outside.
That's exactly right.
So not only do you need to have a trust that's funded or a will in place, but you also need to make sure your beneficiaries are named properly in your IRA. So some people will come and do a will and say, well, I did a will, but then they have $2 million in their IRA that's pointed to nobody or just their spouse. They haven't thought about what happens after the spouse.
Right.
So from a estate planning standpoint, you have to make sure that you look at the complete picture. You may not need a revocable living trust if all your assets are inside the IRA, essentially, except for your home.
That's a very good point. Most people have kind of two buckets of assets when they pass away. Some are the probate assets, which are the ones that pass under their will. The others are non-probate assets, which are things like your IRA, life insurance. These are assets that pass either by beneficiary designation under the contract, by beneficiary designation, or by under the law. So you might say, if you're married, why do I need a will? I own everything joint with my spouse, which a lot of people do own most of their assets joint with their spouse, but very frequently there is some asset floating around out there that they might think they have everything covered, but they don't. Or
they die together in the same auto accident.
Right, exactly. That is not unheard of.
Right, it doesn't help you anymore.
Fortunately, it's not that common, or unfortunately, I guess, depending on your perspective.
Right.
But so these assets that are non-probate, the ones that have beneficiary designations on them, if you fail to name a beneficiary, they end up in your probate estate. So you can have an insurance policy that doesn't have a beneficiary named on it, And under the insurance contract, it supplies the default beneficiary is your estate. And so you can have all this money flow into your probate estate and pass under your will anyway. Or if you don't have a will.
What we're learning here is everyone needs to have a will. They need to have a beneficiary named where there's one needed, IRAs, life insurance, 401ks, all that fun stuff. But then so in the revocable living trust is really for people who are looking to skip the probate process entirely. Mm-hmm. Irrevocable trusts are for those of us trying to get assets out of our estate for some reason. It could be for elder care issues, nursing home, VA benefits, whatever it is that we're trying to obtain. That's what an irrevocable trust would be for. I've only got a few more minutes left, so I want to ask this question that everyone seems to ask me, or a lot of people ask me. I just got an inheritance. How much death tax do I have to pay?
Right. So, and we laugh.
It's probably a fair question because in our world we see this all the time, but
it's one of the most unpopular taxes that exists, in spite of the fact that a very, very, very small fraction of the population is actually liable to pay it. Right now, every person has an estate, and it's a combined gift and estate tax exemption. So you can give it away during your lifetime, or you can give it away when you pass away. But it's $11.58 million per person. And so for spouses, you're talking about, over $23 million that can be passed on to children before there is ever any exposure to the estate tax.
So basically $23 million. If I inherit $23 million tomorrow, that'd be great. Tomorrow, the person who I inherited it from, nor myself, would have any estate tax due.
That's right. Up to $23 million.
And if I inherited $30 million,
there is an incremental tax at 40% for that $7 million difference.
So you lose 40% to the government.
That's right.
The people that get hurt the hardest on that, I feel like, are people who, farmers, people who own a lot of real estate.
So
those with illiquid assets have a difficult time.
They do. There are some safeguards, I guess you could call them, built into the law that are intended to avoid a fire sale of the family farm or the closely held business. But really, families like that are best advised to obtain life insurance to provide the liquidity needed to pay the tax and pay it off quickly. The law allows for it to be paid over time, but that's more expensive.
Right.
There's interest.
So let's shift gears a bit.
Sure.
Thank you for coming on our podcast.
Oh, you're welcome.
I want to give you $30,000 for coming onto our podcast. Don't you wish that was true?
I do.
You'd come on every week, wouldn't you? What's the gift tax that we hear about?
So the gift tax, as I said, that $11.58 million, you can give that away during your life and not have to pay tax. But before you even get to that $11.58 million, each of us can give away $15,000 to as many people as we want to. I can give you 15. I can give everyone that works in your office $15,000 without there being any use of that $11.58 million exemption. And so, but because you're married, you get the benefit of 2 of those exemptions. And that's why you can give me the 30,000 and not eat into either you or your wife's $11.58 million.
So we have the $11.58 million each that we can kind of tap into, and that's done generally at tax time with a single tax form, I believe. It's nothing that
for bigger
complicated.
gifts, if you've exceeded the $15,000,
like if we gave $100,000 away,
or if you've got a big insurance policy, you pay a big premium every year.
Yeah, true.
That's usually where it starts to come up for people. Then you start to get into a situation where you have to file a gift tax return to report the use of your $11.58 million. You don't pay tax, but you have to file a return each year. But if you're only giving below the 15 to people, you don't have any gift tax filing obligation.
I feel like we could just keep talking on and on and on
because
we would just skim the surface of estate planning.
Yeah.
Megan, thank you to you and your team for helping wiser clients navigate through all this. And thank you for coming on with us today.
Thank you for trusting us to help your clients.
Have a great day.
Wiser Wealth Management Incorporated is a registered investment advisor. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. Be sure to first consult with a qualified financial advisor and/or tax professional before implementing any strategy discussed herein. Past performance is not indicative of future performance.